Hello and welcome to Think Like an Attorney. This is a new podcast and our pilot episode, which basically addresses all things law and all things lawyers. We're mainly directed at those who aspire to be attorneys and those who aspire to be support staff for attorneys. So with people with these types of career paths, we're here for you to give you new ideas and new concepts regarding thinking like an attorney. This particular podcast is designed to hit some of the main legal issues of the day, and we are going to present today an historic trial which is coming up and is actually in place right now, the state of Minnesota versus Derek Chauvin. This arises out of the tragic death of George Floyd, who died on May 25th of 2020. This trial is historic from the standpoint that all of the proceedings are basically going to be live cast, live streamed on all of our devices and all of our television sets, essentially. I would like to introduce myself. My name is Brendan Cody. I'm a lawyer in St. Paul, Minnesota. And to my left is Josh Stoka, who is also an attorney in St. Paul, Minnesota. We are right across the river from the trial, which is being held in Minneapolis. We're broadcasting from Paralaw Studios in downtown St. Paul. Our job today is to give our audience an inside baseball view of a trial. We know that a lot of you are watching this trial live as it appears on your televisions and devices. So we want to give you some tips on how to get the most out of your watching, to give you tips for your kind of an armchair quarterback type of view that you have of this trial. We want to give you a guideline. We want to give you a blueprint of what actually happens in a trial. The key point we want to make clear here is that although the trial is televised, it's not television. This is not Law and Order. We all love the show from NBC, Law and Order, but this is not it. This is a live trial with real people. You're going to find that as you watch the trial, it can be a little tedious. It can be a little boring. It can be very slow moving. And this trial will go for approximately 4 weeks is what the estimate is. But I can guarantee you there will be dramatic points in the trial, and you need to watch for those, and we want to help you to catch those points of interest and of importance in regard to deciding the guilt or innocence of Derek Chauvin. Another point I'd like to make clear here is that we take no sides in terms of this podcast. We're not going to argue defense. We're not going to argue prosecution, but rather we're going to take a bit of an agnostic type of approach that we simply want to show you the procedure and what the lawyers and the judge and what the jury has to go through in terms of this trial. So you're going to get a bit of a blueprint, a bit of a roadmap as actually why and how things happen in a jury trial. And I'd like to point out that the jury system in the United States, be it state or federal or local, is the finest system on the planet. It's designed to get at the truth of a matter. It is designed to grapple with problem solving and resolving legal issues by using 12 jurors. There's no system better in this world than what we have here in the United States. We're going to start with a couple of things that you may have seen yesterday. We were kind of on day 2 of the trial, but yesterday the judge gave the jury preliminary instructions on how to actually handle themselves and what is required and expected of them as jurors. So before the trial actually starts, the judge will instruct them verbally that they're not to discuss the case with other people. They're not to discuss the case even among themselves. They're not to discuss the case with family members or friends. They're not to do any internet snooping, no doing any of your own research or anything along those lines. And furthermore, the most important instruction, I think, on the preliminaries is he tells the jury, keep an open mind. All of you must keep an open mind and not form any conclusions until all of the evidence is in. In essence, he's telling the jurors, hold your fire. Right, Josh? What do you think of that issue?
Well, and this is kind of the problem with every juror is anyone who's watched that video, it's hard not to have a conclusion, at least in your own mind. And that's why they have to ask them questions about, yes, maybe you did have a conclusion, but do you have an open mind? I think there was one juror, there was a 20-year-old chemist, I think, who said he hadn't seen the video. So you have to ask probing questions. Have you seen the video? Are you capable of changing your mind if you're presented with new evidence? So that's why the jury selection process is so important, to weed out those people who are incapable of changing their mind given new evidence, even if they did make up their mind after watching that video initially.
Good observation. A thing I'd like to add to that is that in regard to the trial itself, the lawyers for the prosecution are not relying on just the video. They have, at last count, at least 7 expert witnesses on top of that video. So you're also going to see witnesses from the defense as well. And I think it goes to the old adage, there are 2 sides to every coin. And
I was just going to say one thing that, based on, the expert witnesses, there was that MMA instructor that was on there yesterday. And what you'll notice if you're watching the trial is that every once in a while it sounded like he was injecting his personal opinion into his testimony instead of just sticking to his expertise. And, the judge would have the jury leave the room periodically to rein him in a little bit and say, look, you can't give your personal opinion. You have to stick to what your expertise is in his testimony.
Fair enough. After the preliminary instructions are given to the jury and telling them to hold their fire before they make any conclusions, because there's going to be a lot of pent-up frustration and thoughts and ideas and note-taking. And then once the jury gets the case and they go into the deliberation room, they explode into deliberations. They talk with each other. They argue with each other. They give their opinions and observations based on their notes and share them with each other. So those are the things you're going to see that a jury will do. Remember one thing, although the trial is televised, the jury deliberations are not. Those are sacrosanct, they are secret, and they're only for the jurors. It's out of respect for them and the deliberation process. Let's go to opening statements. Once we do the preliminary instructions of the jury, we go to opening statements. And I like to look at opening statements as a way for each lawyer to get a little acquainted with the jury and let them get to know you a little bit. But also, the lawyers will lay out a blueprint of their case, of what they expect the evidence to show. Remember, opening statements as well as closing statements, they're not evidence. Only the witnesses, the exhibits, the videos are evidence. But the lawyers try to help assist and guide the jury as to what they expect to prove. Here's the key point about opening statements, and those were given yesterday, that opening statements are not only a blueprint, but they're a promise to the jury. I promise I'm going to show you certain pieces of evidence that prove my case. If the lawyer falls down on that promise, if they haven't proved that, haven't fulfilled their promise of evidence to the jury that they say they're going to give, you can bet that the jury will hold that against the lawyer in the deliberation room.
I think that's true, partially true and partially not true.
Talk to me.
And the reason why I say that is, you can use this process called priming, where you say something, maybe you don't think you can actually prove it in the beginning, or you don't think you'll be able to prove it later, but if you say it in the beginning, it's already in the juror's head. Meaning maybe they'll, at least in their own mind, saying, well, he didn't actually prove this, but you can't unring that bell. You said something, and it's going to be in their head whether they want it to be there or not. And so sometimes that's the goal of some of these opening statements, is to actually slip in something that you may not be able to get in later.
Fair enough. To keep you keep the idea in their head, so they're, as you say, primed,
right,
to hopefully take your side of the case. Okay. The other thing that we look at, just overall ideas about what a lawyer has to prove. The prosecution in this case, because they are the state and they have the grand strength of the state against the single individual, they're required to prove their case they have a burden, and they have a burden to prove their case beyond a reasonable doubt. We'll discuss reasonable doubt a little bit later, but the point here is that prosecutors must prove things, and the defendant doesn't have to prove really anything at all. That doesn't happen. They will always try to prove their case. But I hearken back to a couple of philosophers here that we'll be discussing that are very old. And one type of philosopher, which was also our president, was our 16th president, Abraham Lincoln. Abraham Lincoln, as a lawyer, was a great trial lawyer. Maybe not a lot of people know that in Springfield, Illinois. He was a great, outstanding trial lawyer. And Lincoln was always grappling with the idea, how do I prove my case? How do I win my case? And he reverted back to 6 books he had from Euclid, an ancient philosopher from Egypt, a mathematician. And you may recall, maybe good memories or bad, high school geometry. Euclid is the father of geometry, and several thousand years ago he came up with Euclidean geometry and basics for angles and lines and points. The point I'm trying to get across here is that Lincoln discovered that the best way to prove a case is almost to conduct a proof. Remember the proofs we had in high school, and you had to go up on the board, and you had statements, and you had reasons, and you had to prove a theorem, and it was very, very nerve-wracking.
I think that's why most of us went to law school, at least the lawyers, is we didn't really understand that stuff too well, but I get your point.
We couldn't understand the math. But I think that it's important to point out that Lincoln talked about proving, but he really didn't want to talk about persuading or convincing a jury. That's what a good salesman will do, but a lawyer has to do something different. They must demonstrate. That was Lincoln's big term, and he looked up every definition he could find regarding demonstrate. He would demonstrate his case. Demonstrating essentially means that we're going to clearly show or prove the truth of a thing. That's it. It's as simple as that. And each lawyer, I believe, is going to have to demonstrate their case and not rely upon convincing or persuading or sales taxes or sales pitches. So that's the thing I think we want to kind of keep in mind when we talk about proof and what they really need to do to win on either side.
I'm going to say this again. I think that's partially true and partially not true.
Okay.
When I was in high school, one of the reasons I became a lawyer is because the O.J. Simpson trial was on. I would come home from school every day, I'd turn it on, and I would watch it. And yes, you can look at it in terms of a mathematical formula, but everyone, even to this day, it's 25 years later, remembers if it doesn't fit, you must acquit. That got into those jurors' head, and that was not a mathematical equation, that was a persuasion technique. He said it over and over and over again, and it stuck in the jurors' heads. I was actually watching the opening statements yesterday, and the prosecutor almost did a similar thing. He said, I can't remember exactly what the phrasing was, like let up, get up, or something like that. He's trying to put an image into the juror's head. He should have let him up, or the cop should have let up, And, that's going to be a persuasive technique. It's not going to be a mathematical formula.
Do you feel the prosecutor will come back to that over and over again?
I think that he probably took the cue from the Johnny Cochran example, is that, yes, you got to hammer a point home. And does it have to make a lot of sense? But it doesn't. It just have to have a persuasive element to it.
It's kind of the old adage, you tell the jury what you're going to tell them, then you tell them, and then in closing you tell them what you told them.
Right.
And he'll probably come back to the recurring theme, which I think is it's a pretty smart move by the prosecutor. When we talked about the O.J. Simpson trial, that's probably the last time that I recall that there was gavel-to-gavel coverage of a trial. Remember, in Minnesota, the general law is no cameras in the courtroom. In this case, the judge made an exception because we want to have transparency because of the very grave and important social issues that are surrounding this particular trial. So this gavel-to-gavel coverage is really historic for Minnesota and historic for the world, I would go as far to say. because the world will be watching, as indicated by many people.
Well, I think this is the second biggest trial, or maybe the biggest trial since that O.J. Simpson trial. And yeah, you gotta have cameras in there. Everyone wants to see what's going on. And I guess I'll be honest, I don't know if that can exacerbate tensions or calm them down. Maybe depend on how it ends up in the end. But I guess it's good to have it be an open process so people can see what's going on.
I agree. And not only is the trial and the testimony open, but motions. Everything in the trial, the motions that are being made outside of the hearing of the jury are given. And so we see kind of the lawyers arguing back and forth, the judge, as to what should be allowed in, what should not be allowed in. I think that what we want to kind of keep in mind here is that when lawyers present their case, sometimes jurors are a little bit leery of lawyers in the beginning, and they don't want to be told what to do. So we take kind of a spin on the old kindergarten phrase, show and tell. Well, in a jury trial, we want to show, not tell. We want to gently, and sometimes maybe a little more vigorously, show the jury your side of the case, not tell them what to do, or order them about, or be arrogant as a lawyer strutting around the courtroom.
I was just going to say something about that. Is if you look at maybe the most prominent lawyers in the last, I'm going to go back to Johnny Cochran. It wasn't that he was, I'm sure he was very smart, but he didn't come across as this arrogant, uppity lawyer. He would speak the language of the jury. And I don't know if you know this person as well, Jerry Spence, he talks about that a lot as well, that, it's almost speaking the same language as them, not necessarily dumbing it down, but too many times I think lawyers just they use big words when they don't have to. And that's what Johnny Cochran didn't do, and that's what Jerry Spence didn't do either.
Right. Brilliant lawyers that not only knew the law and lawyering, but they knew people and how to speak to people on their own level. So this is what I think caused them to have such great success. One other point that when we talk about in terms of overall themes of a trial is relevant evidence. Relevant evidence is a guiding force in any trial. Judges will overrule objections. They will sustain objections, all to the point of relevant evidence. We want to make sure that the jury sees and hears only relevant evidence. We don't want a bunch of extraneous matters or speculation, but rather we want evidence that matters, evidence that has a point, evidence that is significant and actually relates to the issues at trial. Without relevant evidence and objections to relevancy, we would have kind of some chaos in the courtroom, and we certainly don't want to have that. What we'll also see in the courtroom during the presentation of the cases are objections. And a lot of people get a little bit miffed, they get a little bit angry about objections because it may prevent a witness from answering a question. Well, let me tell you, objections are a good thing. It keeps the case, it keeps the trial, it keeps the presentation on track. So if there's an objection, we have rules of evidence. These are time-honored rules of evidence, such as relevancy, asked and answered, repetitive, badgering the witness, lack of foundation. These are basic evidentiary objections that may prevent an answer from coming in, but it's a good thing because it keeps us on track and focuses on just the trial, on just what matters. In addition, regarding evidence and objections, is that the jury can't speculate as to what would that answer would have been. I really want to know, and the judge will admonish them, don't be guessing what the answer would have been. Trust me, we keep this answer from coming in for your good and the good of the trial and the protection of both parties, defendant and prosecution.
Well, that witness, or the expert witness, if you want to call him that, yesterday, when he started kind of giving his personal opinion on his emotions and what he felt, that's not relevant to the point that he was brought on to make about whether his expert opinion on the technique, I guess, that was used in the knee on the neck. His personal opinion has nothing to do with that, so it was not relevant. But I'm assuming a lot of people were watching that and say, why can't this guy say what he felt? you know.
Right.
They may think that that's something that should be out there, but the rules of evidence preclude him from doing that.
Right. And when you talk about the feelings, I like to quote the famous author and talk show host Laura Schlesinger. And she had a great quote, which is in her book as well as her television and radio show, "Your feelings aren't facts." And that theme recurs over and over again with the judge. He wants them to focus on the facts, rational reasoning, rational analysis, not your feelings. And we similarly want to keep those feelings out of the witnesses' hands coming forth. We want them to tell us what you saw through your five senses. These are what we call personal witnesses that have actually been at the scene. And this is the most unusual thing I've seen. And I don't know how much more unusual things we're going to have. This is only day one of the trial. But on day one, as you mentioned, we had a mixed martial arts expert who just happened to be on the curb watching the whole scene go down. What I'm saying is that in most cases, expert witnesses help the jury. Expert witnesses can assist the jury in understanding evidence that otherwise they may not understand. And so experts get qualified, they've got experience, education, training in a certain area. For example, a doctor. They go to medical school, they specialize in residencies, and then they focus on a specialty such as orthopedic surgery or psychiatry. So these people have a great pedigree on training, and I don't doubt that Don Williams, who was the individual that was at the scene, the mixed martial arts expert. I don't doubt that he's an expert, but the issue is going to be, I mean, should you blend, and I think this is highly unusual, should you blend a lay witness with an expert witness all in one package? He was under a lot of stress at the moment too, and he saw a lot of what was happening, and I think he was unhappy and angry and afraid. The point is that expert witnesses usually come long after a case to reconstruct an event. That's what we're doing in a trial. We're recreating an event which has occurred weeks or months earlier. So typically with an expert witness, they look at and they review data, videos, and so forth, statements from witnesses, and then form a conclusion to assist the jury.
No, that's exactly right. And it'd be almost like if a doctor on a personal injury case were to start saying how bad he felt, about one of his patients. They're not allowed to do that. If they get called in as an expert witness, they're allowed to talk about the medical part, but not how they're, personally felt. But you're right. This is it is a completely different situation. The fact that he was on the scene at the time and experiencing these things at the same time as almost testifying as an expert. It almost, and I can't remember if there was some pretrial motion about this, but the fact that you do have emotions involved, maybe does taint your ability to give a reasonable opinion as an expert as well. So
right, and that goes to perhaps impeachment. That goes to credibility, believability of the witness. What I have seen with experts is most experts. They may be hired guns that have done many, many trials, and they have to disclose that. By the way, to each side, each expert we have to disclose that as to how many trials they've done, and do they testify for a prosecution? Do they testify for defense? It's an important thing, I think, to keep in mind, because they might be kind of a hired gun, and also what they're paid is fair game. These experts may be compensated on an hourly basis, paid for by the prosecution, paid for by the defense. So watch for that when you're watching the trial. What are the experts' qualifications? And then look on cross-examination, how much are they being paid? Do they do expert testimony for a living? And so that's the difference between a lay witness who generally doesn't have an axe to grind versus an expert witness that just might do. Their livelihood, the money coming in might be dependent on who they giving the right opinion for the right party. So touching on that a little bit regarding witnesses, that's the core of the trial. You're going to have witnesses that will be on the stand, and I like the way that the camera will focus. I wish the camera would not focus as much on the lawyers. Let's let the lawyers just speak focus on the witness and how they absorb the questions, how they answer the questions, some of their bodily, the body language that they may have, and maybe blinking the eyes or maybe soothing gestures that maybe indicate maybe a little deception here, or maybe not telling the full truth. What do you think of that, Josh?
Yeah, I mean, some people pick up on stuff like that, and some people, don't really. So that's kind of the crapshoot you have when you're working with a jury. You don't know what they're gonna think of a certain situation, So it's always a gamble going to a jury.
Right, and it's always a gamble getting 12 people to agree on one thing. It's a very difficult process, but fortunately, and we'll get to this a little bit later, the judge gives juries very strong guidelines in which to guide them and help them. These guidelines, these jury guidelines, which we'll discuss, are the law of the case. But getting back to the witnesses, I hearken back to another ancient philosopher, and that is Socrates. And Socrates, his Socratic method is still employed in law schools to this day. Socrates said that we get to the truth through questions. We learn the truth through questions. And you're going to see a lot of questions with lawyers back and forth asking questions of witnesses. When one lawyer calls his witness, which is typically the prosecution goes first, which they're doing now, they call their witness and they do what is called open-ended questions or direct examination. They're really not allowed to lead, but they've been doing that a little bit that I saw yesterday.
Judges let it go sometimes for expediency purposes,
right?
So they don't have to take 3 hours to do something that could be done in one.
Exactly. But the danger is they could be testifying for the witness, so we have to kind of strike a delicate balance.
So if the other attorney thinks it's happening too much or they're leading too much, they'll object and say it's a leading question. Then the judge will have to rule on that objection to ask himself whether he thinks that that's being done a little bit too much.
And then the counter to that is cross-examination, where the defense lawyer, for example, in this case, Mr. Eric Nelson, will ask what are called leading questions. Leading means yes/no questions in a sense.
Well, and it's also suggesting the answer in the question.
And he knows the answer, by the way. The lawyer knows the answer generally to those questions, and they want to box the witness in and to maybe at times impeach the witness to show that, well, maybe you're not quite telling us the full story in that type of a method. So again, questions back and forth. But when we talk about the evidence that goes in, the judge has told the jurors that they can take notes, and that's one of the preliminary instructions, but don't take too many notes that you're missing testimony. And so it's interesting because at the end of every break, at every recess, the jurors will leave their pads on their chair. They're not allowed to take those notes anywhere. And it's kind of like court property. And then when we explode into deliberations, when we explode into discussion about the case in the jury room, then they can refer back to their notes and use those notes as another assistive device.
I've seen, jurors have a full book of notes, and some jurors take 0 notes. It's kind of an interesting process.
Right. In addition to the jury instructions, which we'll get to very shortly, the jury is also given a form in which to fill out. They're not just allowed to write a narrative or write a letter to the judge or lawyers. They have specific questions that the jury will have to answer as they go back into the deliberation rooms. And generally it's going to be guilty or not guilty. And in this particular case, there are 3 charges. One is second-degree murder, and then third-degree murder, and then second-degree manslaughter. And the jurors will have to answer guilty or not guilty, check a box on each one, and that's going to be the form. That'll essentially be it. But there's a whole lot goes into how to figure out that form and how to properly give a just verdict. And that's the thing that I think is the most impressive here is that the criminal justice system, the Constitution of the United States has decided, and the framers back 200 and so many years back really got it right by having a jury of your peers, be it a civil case for damages, money damages, or for a criminal case. I think the idea that the framers knew was that if you have 12 people in a jury box and 12 people in deliberation rooms, you can have 12 prisms, 12 different viewpoints of life. it's truly diversity in motion when you have a jury decide a case. I think that when we talk about that diversity, everybody's got some background, everybody has a different type of education, and then you throw them all together. And the jury, I think, over time will bond. I mean, they're going to talk to each other during breaks and during lunch and about small talk, but they'll start forming a bond, and they become, I think, a kind of a mastermind or a jury big brain.
Well, and the first thing they do when they get back to start their deliberations is pick a foreperson. And part of, them being around each other every day is learning about each other and deciding in their own mind, they don't even maybe know this yet, but who that person is going to be. And, it's kind of an interesting process how it's hard to tell as a lawyer how they do it in each individual case, but, eventually, that's the first thing they have to do.
Yes, and the jurors, again, are highly regulated by the judge. They are regulated on what they can consider as evidence with the jury instruction guidelines and general legal concepts, which we'll get into in more depth. But I think that what we have to kind of keep in mind is that the jury is going to have to look at elements of every crime that is charged. There are 3 crimes that are being charged, and elements, which we'll discuss, are kind of like ingredients. Say you're baking a loaf of Irish soda bread, which requires baking soda, buttermilk, butter, flour. If you'd fall down on one of those ingredients, you haven't made your Irish soda bread. And that's the same thing with criminal law, that if you miss out on an element, you must acquit. If the prosecution fails on one element, you must acquit the defendant. So it's kind of a recipe that we have to kind of keep in mind, that elements must be proven. We follow it in a nice, orderly manner. But coming back to the jury mastermind and coming back to the jury big brain, I think the concept here is that one mind is not enough. The framers of our Constitution felt one mind is not enough, 2 minds is not enough. Let's get a large number of people that will have one strong mind. It's kind of like a bundle of sticks. If you have one stick, you can break that stick in half. If you have a whole bundle of sticks, much harder to break in half because it's strong. And I think the strength of many minds, it's kind of like e pluribus unum, which we see on the presidential seal. Out of many, we become one. And we're going to form a mastermind, and the judge kind of helps along with those instructions. The judge, I think, is really important because he's the educator in chief, and he does exactly what my logo says here. He teaches the jury how to think like lawyers. He teaches them the law and how to apply it to facts. Remember, the judge instructs on the law, but the jurors are the finders of fact, and they apply the law to reach a just and accurate verdict. And I think 9 times out of 10, maybe more, juries do get it right, and they do get and issue the correct decision. But coming back to the judge, I think that when we talk about teaching them how to think like an attorney, he's the educator in chief. He teaches them that these are legal concepts that you have to follow and you have to apply reason. Now, we're not trying to turn the jury into lawyers. Maybe we turn law students into lawyers.
Well, that's why the jury decides facts and not the law. And that's why the judge will say, here's what the law is, and here's how you determine or decide whether these facts fit within that law. So they just have to say, is this fact true? Not true,
Exactly. But he really educates them, and they get a real education. And I'm going to go as far as to say that, at the end of every trial, the lawyers are exhausted. The judge is exhausted. The jurors are exhausted, but by golly, they walk taller when they walk out of that courtroom than when they walked in 4 weeks earlier. I think that it instills a real level of confidence that we solve a problem with collective problem-solving skills. And I think that's the heart of the jury experience. The judge, in addition, is kind of a father figure, I think, to mainly the jurors and to the witnesses, and sometimes to the lawyers too. The judge has to preside over this, and I'm very impressed with Judge Cahill. He's not going to be some exciting judge that you're going to see on Law and Order and then screaming at lawyers. He's a very measured, very reasonable judge that is going to be kind of a father figure to the jury, and he'll protect that jury. He protects them from evidence that they shouldn't hear. It's really not evidence that they're hearing if they're not supposed to hear it, but he doesn't want them to be contaminated. This jury process, this courtroom trial process, is almost like a hermetically sealed laboratory, and we don't want to have other things coming from outside to distract from what's really important and what matters. So the judge will protect the jurors. They'll protect witnesses from being yelled at by the lawyers, or the lawyers going too far with a witness, and they'll also admonish lawyers and keep lawyers in check as they present their case. So I tend to see those things when we talk about a trial. Part 2 of our podcast is going to deal with a watch list, a checklist for you quarterback armchair jurors, okay? You're kind of armchair quarterbacks on this one. So when you watch the trial, we want you to watch for certain terms. Certain terms you're going to hear over and over is causation. And then you're also going to hear another term, which is different, medical causation. The jury has to find, if they find guilty, the prosecution must prove guilt from the standpoint that the jury must find that Derek Chauvin caused the death of George Floyd. And then, in addition, there will be medical experts testifying as to why and how he died, which is called medical causation. That's why we have all of the experts. Did he die from the knee and asphyxiation on his neck, or did he die from something else, such as ingestion of drugs or heart attack? So I think those are going to be things that you have to kind of keep in mind as a viewer, that you're going to be seeing those themes over and over again. There'll be impeachment, where we attempt to contradict a witness on their testimony through cross-examination. There'll be the objections, which is what we talked about. There'll be the promises that we talked about in opening statements, and have the lawyers lived up to those promises. There'll be criminal intent. There'll be depraved mind. One of the charges talks about depraved mind, that when Chauvin was there holding the knee on Mr. Floyd for 9 minutes, that with the people crying and yelling and on that curb, and he ignored them, was that a depraved mind? So those are things I think that we're going to be looking at. And finally, reasonable doubt. Reasonable doubt is a full-on instruction, which we'll get to in a minute, that says if you're going to find not guilty, and remember, the defense will try to put up a chalkboard and raise 10 reasonable doubts if they can, because that can let the defendant off the hook. It's not just any doubt. It's not a speculative doubt. It has to be a reasonable doubt. What do you think of that?
Well, yeah, I mean, the reasonable doubt standard is kind of the bedrock of criminal law. If it's in a civil case, they kind of talk about a preponderance of the evidence. You have to prove your case by a preponderance. That's at least in our minds like 51%. It's not as high as reasonable doubt, but the courts have really struggled with how to define reasonable doubt. I mean, they present it to the juror in terms of something like how you would make up your mind in your most important matters of your own life. Perhaps like buying a house, you'd want to check the roof. You'd want to do a lot more thorough job of examining all the important things for the important decisions in your own life. If you're going to the grocery store, that's not an important decision. You don't need to check everything. Cars, houses, maybe spouse, those are the kind of things you want to at least check very hard before you decide to do something like that.
So reasonable doubt has to be an important doubt, a significant doubt. Would that be a fair way to paraphrase it?
Yeah, and courts don't allow you to say, like I just said, 51% with the preponderance. They don't allow you to say like 75% for reasonable doubt, because they don't want kind of a fixed number in the mind. But what I've seen some attorneys do is say there's a spectrum. If you use this table as a spectrum and say there's 0 chance this person did it, and then there's 100% chance this person did it. Obviously 50% is right here. Reasonable doubt is kind of in that range, between 50 and 100%. But they're not allowed to pinpoint an exact number of that percent.
Excellent analysis. So getting to part 3, or our final part, I have referenced repeatedly jury instructions. Okay, so just to review, jury instructions are basically, there are several books of them, and the jury instructions are boilerplate instructions that distill law to a few sentences. So we may have a statute on murder, 2nd degree, 3rd degree, but that statute is distilled down to a few sentences so that it is understandable to a jury. The point is that these jury instruction guidelines are used by judges and by lawyers to instruct a jury on the law. We don't want to reinvent the wheel every time we have a trial. We want to use time-honored, boilerplate instructions that have been compiled by lawyers, legal scholars, and judges who sit on committees in the state and come up with reasonable and effective jury instructions. Now, there was a trial a couple of years ago, state of Minnesota versus Mohammed Noor, and he was also a Minneapolis police officer. He has certainly different facts than the case at present with Derek Chauvin. But the point is, back then they used jury instructions, and that's what I have right here. And we're going to go through a few of them. Not all of them, but just to give you a flavor of what the jury will receive. The judge will orally instruct the jury, and then it's so important that he does it twice. He orally instructs them before they go into that room and gives them a single copy for them to review. So it's that important. They also get the questionnaire that they fill out, which we talked about. But the jury instructions are essentially the law. It is the law of the case, and the jury is bound to follow it. So with the jury instruction guidelines on this case, they haven't been issued yet. But I'm going to be willing to bet that with the same charges in that case that are occurring here, you're going to have the same instructions. So let's go over some of the instructions together. And remember, as a lawyer, I've learned that if you're going to prove a case, go to the jury instructions. You work backward from the end result of what you must prove. It's kind of looking toward the end. It's not really cheating. You're looking toward the end, and you're attempting to find out, what do I need to prove? So giving you guidance as a viewer and listener of the trial, it's important to be aware of these jury guidelines. One guideline here is that there's a presumption of innocence. In every criminal case, the defendant is presumed innocent of the charges that are being made. The presumption remains until that changes with a guilty verdict, but not before. So you must presume as a juror that the defendant is not guilty. The other point that you had indicated earlier, Josh, is that the prosecution must prove their case beyond a reasonable doubt. The law requires the state to prove the elements of the offense beyond a reasonable doubt. It does not require that the elements be proved beyond all possibility of doubt. And again, I'm just selectively indicating some of these instructions because they are a bit long. You have a reasonable doubt if your doubts are based upon reason and common sense. And that's the two watchwords of any trial. You have to apply reason and common sense. Remember Laura Schlesinger, our facts are not feelings. We must focus on the facts as provided. There's other things that the court will talk about in terms of discussions and instruction on the laws, that statements of the judge and attorneys, remember statements by the lawyers, opening statements, closing statements, maybe a comment off the cuff during questioning, or a judge maybe even chastising a lawyer. Those are not evidence, and you're to ignore those and focus only on what the witnesses tell us. We also have to look at evaluation of testimony too, and they give guidelines on to the believability of a witness. Do you believe or don't you believe a witness? Does a witness have an interest or lack of interest in the outcome of the case? Is the witness in any way related to the parties? The witness's manner, the witness's age, their experience. Are they frank? Are they sincere? Is their testimony reasonable given the light of all of the evidence? So that goes to credibility or believability of the witness. We did already discuss expert testimony. Expert testimony is, again, something to assist the jurors on complex matters. So we look at the expert's education, training, experience, knowledge, and ability of this particular expert witness. What sources of information do they have? Have they written books on the topic? Have they done articles on the topic? Are they teachers of the topic in question? There's also the point about the defendant is not only presumed not guilty, but the defendant also has a right not to testify. I think we've seen that before, Josh, with the right not to testify. And how do you feel? How important is that?
Well, I mean, it's a decision that the defendant has to make at the right time. After the prosecution puts their case on, the attorney and the defendant will talk about it. Do we need to disprove something that happened with the prosecution? Or are we fine and we don't think that they've proven their case beyond a reasonable doubt? If they think that's true, you may not want to testify because the other side, the prosecution, is going to be allowed to cross-examine you, and it can get worse from there if that happens. So it's always a tough decision, and it's something they're going to have to decide after the prosecution puts their case on.
They can decide it really at any time before the close of evidence. Is that right?
Well, yeah. I mean, obviously, the prosecution goes first.
Correct.
And then the defense puts their case on. As part of their case, they're going to decide whether he testifies or not.
So, would you hazard a guess, Counselor, as to whether Mr. Shelvin takes a walk down 5th Street, stands on the nickel, or does he testify?
Well, it is important to wait till all the evidence comes out. If the prosecution puts on a horrible case, they've not been, and sometimes you don't know. You just have to make a good guess. That's what a good lawyer is able to do, is say, have they proven their case? He may at least instruct his client, I don't think you should testify. But it's still ultimately his client's decision whether he wants to do so or not.
I think a lot of the jurors are going to want to hear what he has to say. But again, and the other point here, too, is that the jury is instructed that the prosecution can't comment on that. They can't jump on him for not testifying. They have to remain silent.
Well, and there's a specific instruction about that because that's what a normal person would do, is why didn't you testify? So they put a specific instruction here that they can't take anything from that.
Let's go to the heart of the instructions, the charges. First charge is murder in the second degree. Many times you're going to hear the word defined. You're going to hear definitions. So if you're watching this trial, stay alert and sit up straight and listen, because when we talk about definitions, you're going to the judge can define murder, and you're going to hear him define that. In this particular jury instruction, murder is defined as when a person intentionally causes the death of another, but without premeditation. That is second-degree murder. First-degree murder is when you plan and you premeditate and you have a scheme. That's not in play here, but second-degree murder is a charge, and a jury will have to figure out if all of the elements are met. It's interesting because the prosecution really has to prove a lot of things. They have to actually prove that George Floyd died. They probably would put in a death certificate or autopsy. If people think, boy, you have to do that. It's so obvious. No, you got to prove it with particularity. Second, in terms of Mr. Floyd's death, it occurred in Hennepin County. The attorneys have to prove that the death occurred in Hennepin County. Then we go to the basic elements, and we talk about intent to kill. And if they have a purpose of causing death or believe that the act would have caused that result, then the intent is a process of the mind, and they can be perhaps found guilty in that regard. So there are a number of elements they'll have to look at on that charge. I think just from what I've seen and from opening statements, I think that the prosecution is going to try to make a focus on murder in the third degree. Define Third-degree murder is defined as under Minnesota law a person causing the death of another by perpetrating an act eminently dangerous to others, and not or, but and evincing a depraved mind without regard for human life, but without intent to cause the death, is guilty of murder third degree. So it's incredible criminal negligence, I think, what we're talking about here. We'll get to manslaughter in a minute, but what do you think of the depraved mind angle?
Well, I mean, the third degree charge, as I understand it, is you had to act in a manner that could cause harm to others. I mean, and that's going to be the difficulty. And I think this actually was appealed to the Supreme Court, that specific issue in that case, because I don't know if they gave as specific an instruction as they should have in this case. So that's something that the juror's going to have to, figure out.
Okay. Last, we're talking manslaughter in the second degree defined. Now remember, we have three charges here: second degree murder, we have third degree murder, then manslaughter. And I think depending on if he's found guilty, there's a huge swing in prison time. Am I right on that?
I think the second degree was 40 years, and I think third degree was also 40 years.
Okay.
A maximum of 40
A
years,
maximum.
not more than 40 years.
So when we talk about manslaughter, as defined in the second degree, under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death, is guilty of manslaughter. What are your thoughts on the manslaughter, which seems to be lesser culpability?
Yeah, so it's basically, well, negligence is defined as a breach of a duty of care that caused a harm. Basically, that's what it is. What they're going to have to prove here is that, and this could be, the crux of the defense case, and when they keep saying that he was following protocol, that this is what he's trained to do, this is the manner he's trained to do it. He had a duty, to protect this guy. And he didn't breach that duty because he was doing exactly what he was told to do, and in the manner he was told to do it. And the other side's going to make the opposite case. They're going to say, you knew he had trouble breathing. I was watching the opening statements, and it sounds like they're going to bring on a captain who says that once he's cuffed and on the ground, they're not supposed to use that technique anymore. So each side is going to be saying, the defense is going to say, we were abiding by the policy, and the prosecution is going to be saying, you didn't abide by the policy. So that's how you get into the breach of that duty of care, and the jury's going to have to decide who's right.
Good analysis. Final thing, instruction I thought was important is that the judge instructs that you should discuss the case with one another and deliberate with a view toward reaching agreement. The goal is, let's reach an agreement, people. Let's put aside some differences and focus on trying to reach an agreement. But you do that without violating your own individual judgment. I like to use the term, we take our own counsel. We think in our own mind what is best for us and what we recall the evidence to be, and then give a decision based upon that. And what's important about the jury process is that we have 12 votes. The vote counts. Many times, as in these past elections, you're one of several million voters, and you feel your vote when you vote for president or a senator, that your vote is diluted. In this case, with the jury system, your vote counts. The vote clearly counts, and the judge wants to make sure that you don't substitute other people's opinions for your own. Take your own counsel and make your own decision in that regard. I guess we've covered this quite thoroughly. I hope you've enjoyed this show. I like to give a bit of a closing argument myself, and I'd like to take a quote from the movie The Verdict, which was in the 1980s, starring Paul Newman. He portrayed a lawyer, Frank Galvin, who was kind of a down-and-out lawyer. Had alcohol issues, and he was on his last leg, and he gets this great case, a case in his view that you have a woman that was in a coma due to medical negligence, and his client can't speak, he can't communicate, and he's going to bat for a client that is essentially in a coma and trying to get damages for her as well as for her family. And I was really struck by the point that he makes to the closing, the argument with the jury. And it goes something like this. He says, "You are the law." Not some book, not some marble statue, not the trappings of the court. You are the law. Today. And that's what I tell our viewers here in the courtroom of public opinion, that you are the law. And if we analyze things and we look at this case, hopefully in your mind you can reach a just and correct verdict in your own mind. So that's it for today. We hope to see you again soon, and we'll see you next time. We'll see you in court.